Hi everyone, today's unit that we'll be doing is Industrial and Intellectual Property Law, and my name is Shazia Khan. The learning outcome we'll be doing today is Learning Outcome 2, which is to understand the associated laws and procedures relating to copyright and trademark laws and the impact of jurisprudence of both EU intellectual property law and on the UK. So before I go on to Learning Outcome 2, I just want to stress to you what we did, summarize what we did in Learning Outcome 1, which was to understand the rules relating to intellectual property. So it was an introduction to what intellectual property is and the different types of intellectual property. We looked at things like the introduction to intellectual property, such as what it refers to, such as inventions, literary, artistic works, design, symbols, images, etc. We looked at types of intellectual property. We looked at patents, trademarks, copyrights, trade secrets. We used examples such as things like Coca-Cola and Google, maybe Nike. We also looked at intellectual property law enforcement and infringement, where it's a civil action such as lawsuits, criminal sanctions. We looked at remedies for intellectual property, which could be things like injunctions, monetary damages to compensate for the losses and the destruction of infringing goods, and why this is so important when it comes to intellectual property, to protect the intellectual rights of the ones that have created it. We then went on to look at 1.1, which was to analyse the term intellectual property, why it's so important to define what the term is. And it is a legal concept that grants creators who've created the actual invention or the music exclusive rights to their creation. We then went on to look at categories of intellectual property, again, patents, trademarks, copyright, trade secrets. We then went to look at the importance of intellectual property, so the legal framework and intellectual property protection. So we looked at the Berne Convention, which we'll look a little bit more in Learning Outcome 2. We looked at the challenges in intellectual property, and then we went on to 1.2, where we looked at explaining subject matters of intellectual property rights. So we looked at the subject matters for patents, trademarks, copyrights, and trade secrets. We looked at also at 1.3, which was to evaluate types of intellectual property and what the laws were. So we looked at patents and patent laws, such as the Patents Act 1977 in the UK. We went on to look at trademarks and the law related to trademarks. So we had the Trademarks Act 1994 briefly, and then we had the copyright. We looked at copyright laws, which is Copyright Design and Patents Act 1988 in the UK. We then went on to look at trade secrets and the regulations within the UK 2018, how it protects trade secrets. So things like recipes for Coke. We then went on to look at 1.4, the impact of intellectual property on public interest, and we looked at positive impacts of intellectual property on public interests, such as things as encouraging innovation, economic growth, quality assurance. We then went on to look at some negative impacts of intellectual property on public interest, such as access to medicines, knowledge dissemination, monopolies. We looked at balancing intellectual property rights and public interests. We then went on to look at some case studies on intellectual property and public interest. Things like pharmaceutical patents and access to medicines, educational matters, software patents. We looked at relevant case studies such as reforming patents laws, promoting open access, and balancing interests. We then went on to look at 1.5, which was to analyse issues related to breach of confidential information in the intellectual property. And we looked at types of confidential information, which could be things like, formulas, designs, practices for trade secrets, proprietary information, things like information owned by the owner, technical information, data, company's operations and success. And we looked at the legal framework for protecting confidential information, things like trade secrets protection, non-disclosure agreements, NDAs, employment contracts. We looked at common issues in breaching of confidential information, which could be things like employer breach, cybersecurity threats, or third-party risks. We looked at some case studies on breach of confidential information, things like Waymo and Uber in 2017, which was quite a high-profile case where an ex-employee of Waymo allegedly stole trade secrets and shared them with Uber. Another famous case was the Apple and Samsung case, 2012. Allegations of the product design, technical information about that. We also looked at Morgan Stanley data breach, which is where an employee stole confidential data, which affected thousands of clients. And financial losses is another one. Direct financial losses from decreased market competitiveness. So these are some of the consequences of breaching confidential information: reputation damage and legal penalties, fines. It could be sanctions, it could be compensatory damages awarded by the courts to identify that this breach has, you've suffered through this breach. So we looked at the 5 assessment criteria within learning outcome 1. We're going to now move on to learning outcome 2. In regards to looking at understanding the associated laws and procedures relating to copyright and trademark laws and the impact of jurisprudence of EU intellectual property law on the UK. So the aim of this unit is to enable learners to gain an understanding of regulatory and legislative requirements relating to industrial and intellectual property laws. Learners will examine relevant issues, including financial strategy, debt and equity management, the key drivers of shareholder value, corporate governance, and asset portfolio. So the indicative content for learning outcome 2 is to look at trademark definition and the frameworks in the UK and internationally, look at limits, enforcement and infringement of copyright and trademark law, treaty and community trademark system, application for protection, EU approach to intellectual property law and cases that have impacted upon the UK, and the future relationship between EU and UK intellectual copyright law. Key terminology, the UK's 1994 Trademarks Act defines a trademark as which is capable of being represented in the register in a manner which enables the registrar and other competent authorities and the public to determine the clear and precise subject matter of the protection afforded to the proprietor and of distinguishing goods or services of one undertaking from those other undertakings. So introduction to copyright law. copyright and trademark. So, as we said, copyright protects your work and stops others from using it without your permission. And, you know, copyright is important in regards to it gives creators of literary, dramatic, musical, artistic works, sound and recordings, broadcasts, films, and typographical arrangement of published editions, rights to control the ways in which their material may be used. So it protects the work. It gives them exclusive rights to reproduce, and generally it lasts for the life of the author plus 70 years. So, you know, it's really important in regards to copyright to give the rights are exclusively given to the person who's created it. Trademark law. The trademark law provides protection for the use of trademarks. It could be, like we said, brand names, logos, slogans, and other identifiers used to distinguish goods or services. In a business world, a trademark provides product or organization with an identity which cannot be imitated by its competitors. So there's lots of competitors out there that want to imitate, you know, a trademark as it is a symbol. And an example would be the good example of a trademark is Nike, along with the swoosh. You know, the Nike swoosh mark identifies the shoe is actually made by Nike and distinguish them from other shoes made by other companies, like, you know, there may be Puma, Reebok, Adidas. Similarly, the trademark Coca-Cola distinguishes the brown-coloured soda water of one particular manufacturer from the brown-coloured soda water of another. So it might be things like Pepsi, Bar Cola. When such marks are used to identify services rather than products, they are called service marks, although they are generally treated just like the same as trademarks. And trademarks make it easier for consumers to quickly identify the source of a given good. Instead of reading the fine print on a can of Coca-Cola, consumers can look for the Coca-Cola trademark. Instead of asking a store clerk who made a certain athletic shoe, consumers can look for particular identifying symbols, such as for the Nike, the swoosh, or the stripes for Adidas. The impact of EU intellectual property on the UK. So when the UK was an EU member, the law governing intellectual property was to a large extent harmonised across the EU, with certain intellectual property rights enjoying pan-EU coverage. As a result of the UK-EU withdrawal agreement, millions of pre-existing EU intellectual property rights were cloned onto the UK National Register. Those rights came into effect on 1st of January 2021, when the EU and UK systems became fully separate, with automatic reciprocal arrangements falling away. The UK-EU TCA also addresses this area of law, but with a primary focus on affirming standards of protection and enforcement of intellectual property rights, while also providing a basis for future cooperation. The UK has remained a member of the European Patents Convention, but is not taking part in the Unified Patent Court. So when we look at trademarks and designs, EU trademarks and registered companies design RCDs that were registered in the EU Intellectual Property Office before the end of the transition period were recognised as new comparable UK rights. From the 1st of January 2021, these rights, comparable UK trademarks, are designs, and designs are fully independent national rights, which have been capable of being challenged assigned, licensed, or renewed separately from the original EU trademarks. The comparable UK rights created from the international trade marks and designs designating the EU were also created as national rights outside the Madrid and Hague systems. So there are, there are similarities, in regards to that. For example, the law has been defined into UK law. And so, the fact is that, people are still looking at the issue of, the changes, but a lot of it was incorporated into EU law, into international and UK law. So for copyright and broadcasting under EU law, copyright was not addressed in the WA's continued protection for copyright works between the UK and EU as assured by international treaties. These conventions ensure ongoing protection for covered work, regardless of whether the creators and owners are based in the UK or elsewhere. So, there is an overlap with this, with the actual issue around EU and intellectual property. So in conclusion to this, understanding copyright and trademark laws is essential for creators and businesses to protect their intellectual property rights. The impact of EU intellectual property law in the UK, especially post-Brexit, adds further complexity and considerations for intellectual property enforcement and regulation. So, a lot of the laws are implemented into EU laws, and, they have literally kept the same kind of laws in regards to copyright and trademarks. And these are the references that have been used for the first part. So we're looking at 2.1 now, which is to analyse the underlying principles of copyright. As we said, copyright refers to the rights and works of authors in works of authorship as distinguished from patents, whose subject matter is inventions, trademarks, which concern symbols, reputation and goodwill, and trade secrets, information whose value derives from kept secrets. Copyright protects the expression in a work of authorship against copying. Copyright does not protect the underlying ideas embodied in a work, neither does it protect against independent development. Basic copyright protection is automatic, essentially free and more or less worldwide in scope. Although people often speak of copyrighting a work or obtaining a copyright, these are misnomers. The copyright is an original work of authorship come into existence automatically without further action as the moment of fixation of the work. So employers, so the copyrights powers are created, the copyrights empower creators by providing them control over their own work, reproduced, distributed beyond safeguarding, by ensuring the creators can benefit their creations, and copyright laws are put into place so that the laws are not breached. In regards to trying to, identify that, copyright is there to protect the individual's rights, and try to avoid any sort of, try to avoid anyone trying to take, stop copying their rights. A copyright allows the owner to prevent, as we mentioned, the reproduction of substantial part of the copyright. And, the author of the work, actually, the creator, is generally the first copyright owner. If there are two or more authors who've created work, they may have joint ownership of the copyright if the contributions are indivisible or co-ownership. So it's really important. What types of work are protected by copyright, and as we mentioned, it was literally computer programs, databases, artistic work, things like that, and the duration for copyright protection depends on the nature of the work itself. In respect of literary, dramatic, musical, or artistic, generally lasts for the lifetime of the owner plus 70 years after the death, or 50 years if the work was computer generated. So, you know, these we've mentioned earlier as well. Copyright laws in the UK. So copyright laws in the UK framework is primarily governed by the Copyright Designs and Patents Act 1988. This legislation delineates the scope of copyright protection within the UK, granting creators exclusive rights of their work. As we mentioned, it's 70 years following the death of the following person. Copyright in typographical arrangements have the shortest duration, which can be lasting for 25 years from the end of the year in which the edition was first published. In the UK, provided the work is original, copyright will arise automatically as soon as the work is created and fixed in material form without any need to register it. It's important to note that ideas are not protected by copyright. Only the expression of those ideas as fixed in a material form are protected. Given that copyright arises automatically, it is good practice to keep records and evidence of any materials or works created and when. So like an audit trail, which may be intended to establish the subsistence and ownership of the copyright in infringement cases. A copyright owner is advised to mark copyright material when it's published with the international copyright symbol, which is a C, followed by the name of the copyright owner, the year of publication. While this copyright notice is not necessarily a requirement in the UK, it may assist a copyright owner in the event of infringement proceedings, which we'll look at later on. It will also be necessary if a copyright owner wishes to enforce their copyright in certain foreign countries. International copyright laws. International copyright law doesn't exist. Each country has its own domestic copyright laws that apply to its own citizens, and also the use of foreign content when used in one's country. It allows creators and content owners around the world and citizens of many countries to enjoy copyright protection in countries rather than their own. Many copyright issues that appear to be national copyright issues are in fact international copyright issues. Understanding your own country's copyright law is most important, but understanding how copyright treaties and international copyright law works is essential when publishing content or using any sort of content online. So international copyright law and Berne Copyright Treaty. So copyright literally translates to the right to copy, but it's not as simple as that. If your country is a member of the Berne Copyright Convention, then you are likely to have at least minimum protection set out in the Berne, and exceptions to copyright law will be subject to exceptions test in Berne. The Berne Convention is the leading international copyright treaty administered by the World Intellectual Property Organization, which is WIPO. It has close to 200 member countries. Each Berne country automatically provides citizens from other member states with that minimum, the same copyright protections it provides its own citizens. For example, when you photocopy an article in Australia, you apply Australian law, even if the article originates from American or British author copyright owner. Similarly, if you show a French film in public in a US theatre, you can apply US copyright law with respect to the right to perform a work in public. So like we said, each country is unique. It has its own laws. Complementing the framework are treaties administered by, as we mentioned, the World Intellectual Property Organization, WIPO, as the WIPO Copyright Treaty, and the Performance and Phonograms Treaty, WPPT. So these are agreements that are managed within the WPO. As we mentioned, they administer a number of treaties to WIPO. These treaties don't govern the copyright law in any country. Rather, the countries have to adhere to the treaties to include the WIPO minimum standard of copyright protection in their own copyright legislation. Comparison of UK and international copyright laws. So the comparison between copyright laws in the UK and international reveals both similarities and differences. While the UK's copyright legislation provides comprehensive protection for works created with its jurisdiction, international treaties like the Berne Convention, which we mentioned, offer broader coverage across countries. Copyright is the exclusive and assignable legal right given to the originator for a fixed number of years to print, publish, perform, film, or record literary, artistic, or musical material. Copyright law assigned is a set of exclusive rights to the originator, allowing them the right to make and sell copies of their works and to perform or display their work publicly. While the core principles of copyright are similar, the specifics vary from country to country. So I'll give you an example. The United States has one of the most well-known copyright systems in the world. It grants authors exclusive rights to their works for a lifetime plus 70 years. This is largely due to the 1998 Copyright Term Extension Act, often referred to as the Mickey Mouse Protection Act. This law prolonged copyright protection to prevent Disney's iconic character Mickey Mouse from entering the public domain. The United States also has the fair use doctrine, which allows limited use of copyrighted material without permission for purposes like criticism, commentary, news, reporting, education, and research. The fair use doctrine is a key feature that distinguishes US copyright law from many other countries. In the UK, copyright law grants authors copyright protection for the author's lifetime plus 70 years. This is like US, however, is equivalent to the US fair use doctrine in the UK law. Instead, the UK employs a fair dealing system and allows limited use of copyright material for specific purposes like research, private study, criticism, and news reporting. Another example I'll give is Canada's. Canada's copyright law provides copyright protection for the author's lifetime plus 50 years. Unlike the US, Canada does not have a fair use of doctrine, but instead has a fair dealing provisions, which allow for specific uses of copyrighted material for purposes like research, private study, criticism, review, and news reporting. And another one I'd like to give you is China. China's copyright law is rapidly evolving. Copyright protection lasts for the author's lifetime plus 50 years. Enforcement of copyright in China has historically been challenging, but the country is making efforts to improve intellectual property protection. Recent amendments to Chinese copyright law, along with increased enforcement, aim to better safeguard the rights of creators in China, because there's been loads of issues around that. Copyright rules vary significantly from one country to another, with differences in the duration of protection, fair use, or fair dealing, provisions and enforcement mechanisms. As the digital age continues to reshape the creative landscape, countries are adapting their copyright laws to address new challenges, such as online piracy and the sharing of copyrighted material on the internet. Understanding the copyright rules in different countries is essential for creators, consumers, and businesses that operate internationally. It's crucial to respect copyright laws to protect intellectual property and that foster creativity, while also allowing for the sharing of knowledge and culture. Enforcement of copyright law. So effective enforcement mechanisms are essential for upholding copyright protection, as we mentioned earlier, and deterring infringement. In the UK, copyright enforcement entails civil actions, including injunctions and damages for infringement. Additionally, the UK Intellectual Property Office, UKIPO, plays a vital role in providing guidance and support to creators seeking to enforce their rights. Internationally, enforcing copyright laws often requires collaboration among countries through treaties and agreements. This infringement of copyright occurs when someone uses a copyright work as whole or substantial part of it without the copyright owner's permission, and their use is not covered by a copyright exception. In the UK, as we mentioned, copyright enforcement is primarily the responsibility of the copyright holder. So in conclusion, copyright laws represent a cornerstone of intellectual property protection, safeguarding the rights of creators while fostering a dynamic cultural and creative landscape. Understanding the intricacies of copyright laws, both domestically and internationally, is paramount for creators, rights holders, and policymakers alike. By navigating the complexities of copyright legislation and enforcement mechanism, stakeholders can ensure that the principles of creativity, innovation, and culturally exchange remain at the forefront of the global intellectual property discourse. Now we're going to go on to 2.4, is to analyse the framework of trademark as operated in UK, Europe, and internationally. The trademark law plays a fundamental part in role in protecting brands and their distinctive symbols, names, and logos. In the UK, trademark registration gives the proprietor the exclusive right to use the registered trademark on those goods or services for which it is registered. The United Kingdom trademark law provides protection for the use of trademarks in the UK. A trademark is a way of one party to distinguish themselves from another. In the business world, a trademark provides a product or organization with an identity. So, it's really important that the laws are followed in the UK in regards to trademarks. And the relevant legislation in the UK for trademarks is the Trademarks Act 1994. This act implements European directives that create a uniform framework for trademarks across the EU. So it's crucial. Under the Trademarks Act 1994, trademark is defined as a sign capable of being represented graphically, particularly words including personal names, designs, letters, numerals, the shape of goods, or any of their packaging, provided that such symbols are capable of distinguishing the goods and services of one undertaking from those of another undertakings. Your brand will only be capable of being trademarked if it is sufficiently distinctive and identifies your business or products for services as unique or individual. Your brand can be a combination of your words, or it could be pictures or logos. So as we mentioned, trademarks in the UK are primarily governed by the Trademarks Act 1994, which protects individuals' rights under the Act, and it protects their brand identities under their rights. Once your trademark your trademark, once registered, protects your business brands and acts in a guarantee of origin. Trademarks allows consumers to differentiate between products and services. Trademarks law in the EU. So within the EU, trademark protection is harmonised across member states through the EU trademark regulations EU 2017/1001. The regulation establishes a single trademark known as European Union Intellectual Property Office, EU IPO, providing businesses with the option to register EU trademarks. It offers protection across all of EU member states and offers protection within brand presence within the EU market. The EU trademark framework enhances market integration, promotes border trade, and facilitates brand recognition. For unregistered designs disclosed in the UK since 1st of January 2021, there may not be no grant of right in the other territory, while with first disclosure in the UK securing the new UK supplementary design right, while first disclosure in the EU secures the OCD rights. International trademark law. Beyond national and regional frameworks, international treaties and agreements govern trademark protection on a global scale. So the Paris Convention and the Protection for Industrial Property is a cornerstone treaty that establishes the minimum standards of trademark protection among the member states. Additionally, the Madrid system for the international registration of marks offers a centralized mechanism for registering and managing trademarks across multiple jurisdictions. By participating in international treaties and managing trademarks across multiple jurisdictions, businesses can extend their trademark protection beyond domestic borders and access streamlined procedures for managing their trademark portfolios worldwide. Key elements for trademarks. So trademark law encompasses various elements crucial for establishing and protecting brands. These include distinctiveness. So the marks must be distinctive to qualify for a trade protection. Registration. So formal registration provides legal recognition and enhanced rights. Use in commerce. So trademarks must be used in connection with goods or services in commerce to maintain protection. Infringement, unauthorized use of trademark that causes confusion or delusion may constitute infringement. And enforcement. So trademark owners have the right to enforce their marks through civil actions, including injunctions and damages. So that is what the court will award them if it goes through the courts in regards to whether they can enforce their rights or not. Enforcement of trademarks. If you actually own a registered trademark, you may encounter a person or company who attempts to use that trademark for their benefit. In this instance, your business could face reputational damage as a result of the trademark's misuse. However, you should be aware that you have the right to exclusively use your registered trademark. Consequently, you can enforce your rights if someone uses your registered trademark without your consent. So it's really important that you know that you can enforce your rights. Enforcement can take many forms, including informal agreements, alternative dispute resolution methods such as mediation and court proceeding. Businesses use the sign against any trademark, whether registered or not. Unregistered trademarks are more complicated to enforce than registered trademarks. Therefore, using the symbol trademark TM symbol can deter others from misusing your trademark. The symbol notifies other businesses that you are actively using the trademark and that they should recognize its status as a trademark and importance in relation to your brand. On the other hand, the symbol R represents registered trademarks. So you can only use the symbol once you have registered your trademark with the Intellectual Property Office. An essential element of enforcement is deterring competitors from using your trademark in the first place. And you can do this by publicizing your trademark registration. So, as we mentioned, mediation was an alternative. Alternative dispute resolution mechanisms, mediation, arbitration, collaborative efforts among national authorities, customs agencies, and international organizations enhance the enforcement capabilities and combat counterfeiting and illicit trade on a global scale. Trademark laws serve as a cornerstone of intellectual property protection, enabling businesses to safeguard their brand and their identity. So it's really important that as a business, if you find businesses using your trademark without your consent, you should act quickly and efficiently. If you fail to act, your competitors continue to use the trademark, can cause you financial and, as we mentioned, reputational damage. So it's really important. If in any instance, as we mentioned in that slide, mediation proceedings are unsuccessful, you can resort to formal legal proceedings to instruct legal professionals to represent you at court. Your trademark, you need to make sure that when you look at enforcement rights and your reputation, you need to make sure that you need to bear in mind that your trademark is linked to your brand and represents your business to your customer base. Therefore, if someone is misusing your trademark without your consent, you should send them a letter requesting them to not use it immediately, then mediation, and then court proceedings. So, it identifies that you are doing something about that. 2.5, evaluate limits, enforcement, infringement of copyright and trademarks. Copyright and trademark laws provide vital protection for intellectual property, safeguarding the rights of creators and businesses. However, these laws are also limitations and mechanisms for enforcement to ensure compliance and deter infringement. Limits of copyright and trademark protection. So copyright and trademark protections have boundaries to balance the interests of rights holders and the public. For instance, the fair use of doctrine allows limited use of copyright material without permission for purposes such as criticism, commentary, news reporting, teaching, scholarship, or research. Similarly, trademarks can become generalized if they're commonly used to refer to a category of products or services rather than a specific brand, leading to the loss of protection. Civil and criminal enforcement. Criminal offences which are counterfeiting and piracy, infringement of trademarks and copyrights can be criminal offences, as well as being actionable in civil law. A range of criminal provisions are set out in relevant acts. The other offences, such as those under the Fraud Act, may be applied because what they are doing is fraud. So just again to reiterate, intellectual property results from persons' creativity and ideas. Under the criminal law, certain uses of copyright registered designs or trademarks without the owner's permission can amount to a criminal offence. These are often referred to as piracy for a copyright infringement, intentional copyright copying for registered designs, and counterfeiting for trademark infringement. As a crime, the infringement of intellectual property rights may not leave a bruise, a home ransacked, or a person abused, but it permeates all walks of life and business and is growing hugely. There are a variety of marketplaces for fake, copied, and pirate goods. It penetrates the supply chain by door-to-door sales, online sales, market stalls, street sales, car boot sales, and even high shop streets. Prosecutors should consider offences under the following when dealing with counterfeiting, copying and piracy. So you've got in the UK Copyright Designs and Painters Act 1988, which is section 107, 198, 296, ZB and 297. Sections 107 and 198 as amended by the Digital Economy Act. You've got also the Trademarks Act 1994, section 92, the Fraud Act 2006, Video Recordings Act 2000, text section 9 and 14, Proceeds of Crime Act, and you've got Registered Designs Act 1949 as amended by Intellectual Property Act 2014. So, you know, it's really important that you, if infringement of copyright is it's a criminal offence, it's deliberate infringement of copyright may be a criminal offence. Pursuing the criminals can involve the police or trading standards department. However, many of the copyright-based industries concerned about this type of crime have formed organisations representing their interests. So as we mentioned, both copyright and trademarks owners have the right to enforce intellectual property rights through civil litigation. In cases of infringement, can seek such as injunctions, you know, or monetary damages. Like we mentioned, criminal offences can be pursued or in the form of counterfeiting or, you know, piracy. Legal ramifications. So infringement of copyright or trade can be serious legal consequences. Civil lawsuits and criminal charges, as we mentioned, in regards to the different laws that apply to it and the different sections of the law, that it is a criminal offence. Fair competition and innovation. While copyright and trademark laws aim to protect the rights of individuals and creators of businesses, they also serve broader societal interests. These laws encourage fair competition by preventing unfair practices, such as copying or intimidating distinctive works or brands. Moreover, they foster innovation and creativity by providing incentives for investment in new ideas and products, ultimately benefiting consumers and the economy as a whole. For example, a dominant firm additional intellectual property may serve to entrench or prolong its monopoly position, while the same right may be held for a small rival might serve to destabilize the dominant firm and make the industry more competitive. You know, so therefore, when you look at intellectual property, you know, it's important in regards to fair competition and innovation. In conclusion, understanding the limits, enforcement mechanisms and consequences of copyright and trademark laws is essential for creators, businesses and consumers alike. By respecting intellectual property rights and complying with legal requirements, stakeholders can contribute to a fair and thriving marketplace that promotes innovation and protects the rights of all parties involved. So it's really important that, you know, people are aware that, you know, individuals, if you are copying something, you know, individuals do have rights. The creators of that do have the rights. So, you know, it could be an enforcement. It could, if you're found guilty, you can receive, you know, like imprisonment or, you know, it may be a criminal offence. You know, you may have to go to court if it's such as counterfeiting or piracy. You know, so you've got to be really important when you look at, you know, copying something, that you are taking into account the issues around the criminal offences or the laws around it, because, you know, there are laws in place both nationally and internationally that would protect the creators' rights. So you have to make sure that you are looking at the laws in place and how the laws come together to protect intellectual property. And if it's a criminal offence, then you need to make sure you are looking at not doing anything that would make you commit an offence. So we finished learning outcome 2 now on industrial and intellectual property unit. These are some of the references used for learning outcome 2, which we've got WIPO, World Intellectual Property Organization 2021. We've got UK Intellectual Property Office 2022, European Union Intellectual Property Office 2021, Trademark Law, World Trade Organization 2020, Trade-Related Aspects of Intellectual Property. Number 5, UK Government Intellectual Property Crime and Infringement. Make sure that, again, some preliminaries just there, that you are referring to ebooks and journals on Moodle for this unit, and any sort of additional reading is on Moodle for you to go onto and do the additional reading. Any sort of journals, anything will be on Moodle. If you have any questions or any queries, kindly email learnerwork@ukvarsity.co.uk. Submission of the assignment to be done on learnerwork@ukvarsity.co.uk, and that would be, submission is normally 2 weeks after the completion of the unit. So we've done learning outcome 1 and 2 now. The next learning outcome is 3 and 4. And then it's the assignment discussion. So make sure you are reading around learning outcome 1 and 2, which we've done today. And then next week is learning outcome 2 and 3, 3 and 4. If you have any questions, again, please email learnerwork@ukvarsity.co.uk. And thank you for attending today's session. And I will see you in the next session, which is learning outcome 3. Thank you.